by this court.
Well, to unpack some of the legal arguments we heard today, I'm joined now by the advocate Romeo Nthambeleni. Romeo, good evening to you, and thanks once again for your time on The Pulse tonight. As I understand what Zuma's legal team, the former president's legal team, had to do here, they had to essentially prove that another court could have come to a different decision. How difficult was that? I mean, how difficult is that test for them to achieve?
Okay. Good evening, Steve, to you and the viewers. I think, as you have correctly pointed out, the main issue that they wanted to argue is that a different court can reach a different conclusion, the different court being the Supreme Court of Appeal in this matter, after their dismissal by the same judge. So I think that is the basis which they had to actually argue throughout this afternoon, to try and persuade the judge that he might have gotten it wrong when he dismissed that application.
Do you think they've been able to do that? And I realize that's always quite a difficult argument to assess. Yeah. I mean, you and I can't be in the judge's mind.
Yeah, absolutely. For me, following the arguments on both sides, I think the arguments on behalf of the state will find favor in the state, because the main issue that was being pushed here is the interest of justice. And the argument of the state says you cannot put the cart before the horse. Wait until a conviction is secured, and then you can be able to escalate this matter to the Supreme Court of Appeal. And also the issue of the interpretation of the Porritt case, whether it was correctly interpreted by the Supreme Court of Appeal or not. And I think that is the basis of the argument. So for me, the way I look at it, the argument of the defense might actually find the favor with the judge to actually dismiss that application as well.
So, I mean, the way that it all kind of pans out as well, I mean, as I understand it, the risk, I suppose, for a judge would be if he decided to say, yes, you can have another appeal, yes, in the end, Advocate Billy Downer is removed as a prosecutor, there'll be nothing to stop Zuma's legal team from coming with another application to remove whichever prosecutor replaces him.
Actually, Steve, what you're saying is correct. The issue is not only with Billy Downer, it's with the entire NPA. So if you are successful in removing Downer, you're saying that no one in the NPA will be able to have a title to prosecute, because you're saying that the entire NPA is tainted. So, the moment you are able to remove that pillar, the whole deficit of the NPA collapses, and you will not be able to prosecute. So it means that all those 730-something charges that we're talking about, they automatically fall away, and is entitled to be discharged in all those charges.
So, in other words, for the NPA, this really matters. I mean, if they lose this, if not this case, but if they lose the entire application, I mean, they could lose the entire case. So they really have to win.
Absolutely. You're correct. There's no option of actually losing here, because besides that, it's precedent setting to all other cases, to say that if then this issue of a prosecutor having to title to prosecute, as decided in the SCA in Porritt case, turns around in the matter that we are actually dealing with, then it means that prosecutors will have a mountain to climb in terms of prosecution if ever there's issues that are raised that are similar, in terms of facts that are before the court at this juncture, Steve. So it's very important what you're saying, that the whole matter rests on the credibility of the NPA as well as an institution.
So if Zuma's legal team loses this, if he loses this argument, what options do they have after that?
No, they can petition the SCA, and then we can hear from the SCA what is the decision relating to their argument, because what the state is actually arguing is saying you can do this appeal later if you've got grounds on facts of law, and then you can be able to do it later, but allow the normal trial proceedings to actually start and run on the plea that you have actually entered, and the plea of not guilty. And that is not what they actually want. They say, no, we cannot allow this, because it is in the interest of justice for us to pursue this line of appeal, because if we don't allow that, then justice will be done, injustice will be done for our client, because he would have gone through the entire rigmarole. So the whole process of how the former president has been litigating doesn't help him as well, because there were matters that he has been postponing for quite a while, and I think that will not find favor in the judge.
Romeo Nthambeleni, Advocate Nthambeleni, thank you very much indeed for your analysis tonight. I do appreciate it.